for Ms. Clough.
And
So,
Judge, if I could put the offer on record, just since we're all here.
yes.
So I've offered Ms. Clough an offer to an attempt home invasion third, dismissing count 2. And in light of her treatment that she's undergoing, and I believe what I heard was recovery court, we had offered her no initial incarceration. And I did prepare an amended information and a plea form for that, and I'll forward them to the court upon hearing if there's an acceptance or not. But those documents are prepared whenever she's ready.
So just so I clearly understood, it's an attempted third with no immediate jail.
Yes, and I believe I sent that to you back in April.
Yeah, Ms. McClure, you probably did, but I can't find it in the file. So
I can resend it.
yeah, if you could, that'd be great. And then now,
how old are you?
I'm sure.
I'm 28 on the 22nd. 22nd,
Right.
I'm sorry, 22nd.
Okay, so the plea agreement is an attempted home invasion third, which is 2.5-year felony. Dismiss count 1 and count 2. You would plead to the added count 3. Is that correct? And no upfront jail as long as she's in compliance, Ms. McClure?
Yes.
All right, so I'm going to set this out to August 6th at 8:30 a.m. And Ms. Adams, if I could get a notice of hearing for Ms. Clough. So August 6th at 8:30 in the morning. So my assistant will bring out to you a notice, okay? So I can't talk to you because you're not part of the proceedings. Ask your friend what she wants. Okay, all right. So, all right, have a seat right behind you on that bench and we will get you a notice of hearing.
Thank you, Judge.
Thank you. This is in my waiting room. Mr. Goldstein, all right. I have a gentleman on an iPhone with a beard. Go ahead and unmute your device, please. And what is your name?
Andrew Wright.
Andrew Wright, okay. And I'm looking for your client, Mr. Goldstein, so.
He's in the building, Your Honor. He just called me. I told him to go up to your courtroom.
Oh, he's here, okay. All right, come on up to the podium, sir. So, Mr. Wright, you are represented by Mr. McManus. I'm gonna put a backslash in McManus's name. So I'll put you in the waiting room, and as soon as he gets here, you're a little bit early, I'll bring you back in, all right? All right, and you are James Burton. So this is in the matter of the people of the state of Michigan versus James Ray Burton II, file number 24-21884FH. I have David Goldstein appearing on behalf of Mr. Burton. I have Phoebe McClure appearing on behalf of the people. This is a date and time set for a pretrial conference. Ms. McClure, or Mr. Goldstein, how would you like to proceed?
Well, Your Honor, first of all, as the court is aware, there was a jury trial held in this matter and the jury hung. I do have most of the discovery that I obtained both from my client and from Mr. Brooks, who was prior counsel. But the one thing I don't see is a transcript of the trial. And the question is, was that ordered? I do have, I believe, the tapes, but I would like a transcript.
Hold on, Mr. Goldstein, could you pause for 1 minute? There was no.
Sure.
Oh, okay. So Mr. Goldstein, Ms. Spade has a mind like a trap and I do not. So evidently there was a trial, it was a hung jury, there was a plea offer made to your client. He said he was going to accept it. That never occurred. I don't know why. And then so that's why there is no transcript.
Oh,
evidently.
it was never ordered as far as I know, Your Honor. I
Yeah,
understand.
Judge, if I could weigh in, first, I didn't know Mr. Brooks was no longer on the case. We don't have an appearance that was sent to our office for Mr. Goldstein. And secondly, the plea offer that was accepted at the time we consented to the hung jury was that Mr. Burton was going to do diversion, and my understanding was that was still happening. So if that's not the case, that was never relayed to me. As far as I know, he was still going to complete diversion.
This is the first time that I have heard diversion from either Mr. Burton or Mr. Brooks. So that's all new to me, Miss McClure.
Mr. Burton's met with Mr. Wendt in our office since the hung jury, and my understanding was he was going through with that.
Okay, again,
Are you working with Bob Wendt?
I talked to him one time, and then he was supposed to get a hold of the prosecutor. Never heard anything back.
Okay, so how long of an adjournment do you want to get all the information, Mr. Goldstein?
well, Your Honor, I suspect that you are probably setting jury trials for late fall, if not the beginning of next year. So I don't
Late
have any
fall.
problem. I'm sorry. Yeah, I don't have any
Like-
problem to go ahead and setting a trial date. That would not preclude further negotiations between myself and Ms. McClure. It would also not preclude me from finding out about this diversion issue, because as I said, this is the first I've heard of it. So why don't we go, unless the court has a problem with that, let's go ahead and set a trial date.
So, Ms.
guess
McClure?
Yeah, I don't know, Judge. I guess I have somewhat of a problem with it because I'm quite positive we put on the record that we were only accepting the hung jury and pulling the jury from continuing deliberations because we had come to this agreement.
So I think one of two things need to occur. We need to order a transcript, I'm assuming. So we give 90 days to complete a transcript.
Well, Your Honor, given what Ms. McClure just said, why don't we start with a transcript of that portion of the proceedings? Because
Okay.
if something was placed on the record, I need to know what that was. And at this point, like I said, it's the first I've heard of this.
It was.
So
Okay.
why don't we adjourn till maybe the middle or end of August and get a
Okay.
transcript of just that portion rather than the entire.
So, Ms. Spade, do you think that portion of the transcript could be completed by mid-August? Okay, so I'm gonna set this over to August 27
Second.
at 8:30 in the morning. Mr. Burton's here in person, so we'll do the notice of hearing, Mr. Goldstein. So August 27 at 8:30 in the morning, it can be via Zoom. Do you have our Zoom information?
Yes, I do.
All right, so Miss Adams, if you could do the notice of hearing, and I'll have you have a seat on that bench right behind you. Yep, right there. And we will get you a notice of hearing. All right, thank you, Mr. Goldstein and Miss McClure.
Thank you, Your Honor.
Judge.
All right.
And Mr. Goldstein, if I do want to make sure you have all discovery, so if you do want to confer with our office, I can make sure you have everything.
Okay, I know who you are, but anybody else here have a court date or just here to watch? You have a court date? All right, so the gentleman in the middle, what is your name?
Antonio Hodge.
Mr. Hodges. All right. Your attorney is Matthew Murphy and is
Morning, Your Honor.
oh, he is here. All right, Mr. Hodges, and then might you come up? Just stand, yep, stand right there at the podium. So this is in the matter of the people of the state of Michigan versus Antonio Demetrius Hodges, file number 25-22119 FH. I have Matthew Murphy appearing on behalf of Mr. Hodges, and I have Alexander Bayonetto appearing on behalf of the people. This is date and time set for pretrial. We are scheduled for jury trial for one day on July 15th of 2025. I do see the last plea offer that was made in this case was to plead to count 1 as charged, which carries the probation term, maybe county jail, and dismiss the habitual offender 4th offense notice. So, where do we stand today, Mr. Murphy and Mr. Banetto?
Your Honor, I need to speak with my client in a breakout. I don't have a good working phone number for him, so I haven't been able to communicate with him about the prosecution's changing the offer.
Okay, so what I'm going to ask you to do, Mr. Hedges, is you and I are going to walk out in the hall, and I'm going to connect you to a Zoom device so you can talk to your client or your attorney. But so, hold on 1 second. All right. Step out in the hallway. Need an IT. Well done. Nothing in here. Right, Mr. Hodges, I'm gonna send you a request to unmute the device out there. Go ahead and unmute. Good job. And then I'm gonna send you a request to start video. So go ahead and start your video. Perfect, okay. So now I'm going to assign you to a breakout room with Mr. Murphy. So when you get an invitation to join, just click on join the breakout room. When you're done, don't even worry about shutting it down. Just come back in the courtroom, okay?
Yes, ma'am.
All right, there you go. Perfect. Okay, so does anybody in here have Sam Malaro as an attorney? You do? Why don't you come up to the podium? I gotta get rid of Sam and Matt first, Mr. Casper, so they can go to Judge Olsager. What is your name? Miss Rember, let me grab your file. Right, Mr. Malaro, I have Malika Rember here. So this is in the matter of the people of the state of Michigan versus Malika Nataya Rembert, file number 24-21966FH of Salvatore Malaro, appearing on behalf of Ms. Rembert, and Phoebe McClure, appearing on behalf of the people. This is the date and time set for a pretrial conference. So, Mr. Malaro, how would you like to proceed?
Judge, if I could have a breakout with Miss Rembert, I think we can get this worked out.
Okay, well, I can't right now because Mr. Murphy's using it.
Oh. I mean, looks like a plea agreement that was received yesterday that I need to talk to her about.
Okay, do you want her to come over to your office? You want to wait till Mr. Murphy's done?
Yeah, if she could come over, that'd be great.
So you have a couple choices. We can wait a few minutes and you can go on the Zoom device in the hallway, or you can walk across the street to Mr. Malaro's office if you know where it is.
I don't know where it's at, but I have my baby in a car with a social worker from Catherine Cobb, and she can't like stay in the car with the baby while I go across the street.
Okay.
So can I just wait?
Yeah. So have a seat right over here, and then Mr. Hodges comes back in, I'll send you out the hallway, all right?
Thank you.
You're welcome. All right. What's your name?
Michael Gonzalez.
Who's your attorney? Mr. Malaro? All right, so why don't you come on up? All right, so this is in the matter of the people of the state of Michigan versus Michael, is it G-O-N? No, yeah, Goncalves, file number 25-22311FH. I have Salvatore Malaro appearing on behalf of Mr. Goncalves, and this is the date and time set for arraignment. I have Phoebe McClure appearing on behalf of the people. So, Mr. Malaro, do you waive the reading of the felony information?
Yes, Judge, we would acknowledge receipt of the information, waive its reading in open court. And I believe we have a plea agreement that I've received via email, looks like, where Mr. Goncalves is going to plead guilty to larceny, 200 to 1,000. There is no sentence agreement. People will dismiss the original felony charge. There will be restitution in the amount of $1,400. I believe that is the entire plea agreement.
Okay, so Mr. Goncalves, let's pause for a minute. So I'm going to have you go out to that device in the hallway, and I am going to put you in as soon as well, you can wait a minute. I guess it's Mr. Malaro anyway. All right, so hold on just a minute. All right, Mr. Goncalves, do you understand the plea offer on your case is if you plead to a 1-year misdemeanor, which you could carry as a maximum penalty of up to 1 year in jail, which, you know, we don't typically do. You would probably be looking at 12 to 18 months probation and restitution in the amount of $1,400, and the felony would be dismissed. So do you understand that's a plea offer that's been made?
Yes, ma'am.
All right. And you waived the reading of the felony information, Mr. Malaro, did you say that?
I did, Your Honor.
Okay. So are you asking if your client wishes to avail himself of the plea bargain today, or?
It's my understanding he does wish to enter that plea, yes.
So you want to plead guilty to that today?
Yes, ma'am.
Okay, you want to raise your right hand? There you go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, can you state your full name for the record?
Michael Daquan Goncalves.
All right. So, sir, you've heard the statement of your attorney and the prosecuting attorney. So is it your intention then to plead guilty to an added count to larceny 200 to 1,000, which carries a maximum penalty of up to 1 year in jail and restitution of $1,400?
Yes, ma'am.
Are you satisfied with Mr. Malaro and the advice that he has given you?
Yes, it seems to have worked out okay.
Okay, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Your Honor.
Is that correct, Ms. McClure?
That is correct. The only thing I'll add as to restitution is it is joint and several with a co-defendant, and I'm not sure the status of the co-defendant's payment. And additionally, the plea form that we have is for district court. I don't know that if we have one for circuit court.
Okay, I don't have a plea form in my file.
Right.
I don't know the status of Mr. Rogers. Has he already pled?
Yes.
All right, so you understand that $1,400 is to be divided between the two of them, is what you're saying?
Yeah, I just don't know how much he's paid, if any.
Okay, so you
Your Honor.
understand you're both, yes.
If I may, I explained to Mr. Goncalves that it's a joint and several obligation, and that if he ends up paying more than 50%, he would have a legal claim against the co-defendant to be reimbursed.
Okay, do you understand all of that?
Yes, ma'am, I do.
Okay, so other than that, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court, correct, Mr. Malaro?
That is correct, Judge.
Ms. McClure?
Correct.
As far as you're aware, is that correct, Mr. Gonzalez?
Yes, ma'am, it is.
All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if I accept your plea, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial?
Yes, I do.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Could you repeat it?
Yep, I could. So do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application or request for leave to appeal and not by right? So had you gone to trial and gotten convicted by a jury, you would have an automatic right to appeal. But because you're entering a plea, you have to request the right to appeal.
Okay, yes, I understand.
Okay. And do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. There's no sentencing agreement in your case, so it doesn't, is not as relevant. So if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, how do you wish to plead to the charge that, let me get back there, on or about December 11 of 2023 in Madison Township in the county of Lenawee that you did commit the offense of larceny 200 to 1,000, guilty or not guilty?
Guilty?
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
All right, how old are you?
27.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
I understand.
Okay, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Judge.
Ms. McClure?
None, Your Honor.
Right. Has your attorney promised you any particular sentence or estimated what your sentence will be? Like, did he say jail time or probation or fines and costs, or did he tell you exactly what it would be?
No, ma'am.
Okay. Is it your own choice to plead guilty?
Yes, ma'am.
All right. So, Mr. Gonzalez, on December 11 of 2023, were you at Advanced Auto Parts?
Yes, ma'am.
All right. Is that located in Madison Township in the county of Lenawee?
Yes, ma'am.
All right, and when you were there, did you and another individual steal a transmission?
Yes, ma'am.
Would you agree for purposes of the plea that the value of that was about $1,400?
Yes.
Okay, and you had no right to take that, correct?
No.
All right, Ms. McClure, are you satisfied?
Satisfied, Your Honor.
All right. Do you want, I'm sorry. All right, has the court complied with the MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has.
Ms. McClure?
Yes.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation because it's a misdemeanor. I'm going to set sentencing, and Ms. Adams, could I get a notice of hearing for Mr. Goncalves, August 22nd? Are you available that day, Mr. Mallow?
Let me look real quick. Says I am.
Okay, so I'm going to set sentencing for August 22nd at 8:15 in the morning. So you can appear via Zoom or in person. Are you working right now?
Yes, ma'am.
All right, so do you want to appear via Zoom or in person?
Most likely Zoom.
Okay, do you need Zoom instructions?
Yes, ma'am, I would.
You should have some right there. So we're gonna make a copy of the Zoom instructions, all right? So next Thursday, not tomorrow, but a week from tomorrow, I need you to report to the district court probation department.
Yeah.
And you're gonna meet with a probation officer. They're gonna ask you about your background, the events that occurred, be truthful with them. They'll prepare a pre-sentence report. I will send a copy of that to Mr. Malaro about a week in advance. So make sure you reach out to Mr. Malaro's office to review that. I think they send you a copy of it too. And then we will see you back via Zoom on August 22nd at 8:15 in the morning. And anything else, Ms. McClure or Mr. Malaro?
No, Judge.
All right, so you go to district court probation on the first floor.
Okay, and that's not today.
No, a week from tomorrow.
Okay, that's what I thought. Okay.
Yeah,
I
so-
do have two more things to add. But I have something to, it's my job to let them know that I had notice to appear today because they say they need that from me.
Okay,
also.
Miss Adams, could I get a copy of, well, what do we have? Do we have a notice of hearing he had to come for today? Like, what will we have had for today? Can we print something off for him? It's an arraignment. Hold on, we're gonna get you something.
Okay, thank you very much.
You're welcome.
And then also, I apologize for being a couple minutes late. I was in the wrong courtroom next door. I've never been up here.
It's okay, it's a long one. It's okay, but I appreciate you. All right, so she's gonna get you a notice for today's hearing. You've got one for the next one, right?
Yes, ma'am.
All right, have a seat on that bench right there. Why don't you step out in the hallway and I'll put you in a breakout room with Mr. Malaro. And then, you need some?
No,
Oh, no, okay.
I was just looking at you to see if you.
No. All right, so Mr. Malaro, I will put you in a breakout room with Ms. Rembert.
Thank you, Judge.
You're welcome. All right, Mr. Casper. All right, Mr. Casper is here and Nathaniel Garcia. All right, this is in the matter of the people of the state of Michigan versus Nathaniel Manuel Garcia, file number 25-22220FH. I have Bert Castleberry appearing on behalf of the defendant, and I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a second pretrial conference in this matter. Mr. Castleberry, how would you like to proceed?
Your Honor, we are very close to working this out. I need one more adjournment if possible.
All right, my next available pretrial is August 6th or August 13th.
Hold on with me.
All right, I'll set it over to August 6th. Miss Adams, Mr. Garcia is present in person, so could I get a notice of hearing for August 6th at 8:30 in the morning, please? All right, so you just stay right there and we will get you a copy of that notice. And Mr. Castleberry's here if you want to get his notice too. All right, thank you, Miss Adams. All right.
And
so-
Mr. Castleberry, if you just want to let me know what you decide, if anything, and I can prepare the documents ahead of that August 6th date.
Thank you.
All right. All right, Mr. Hedges, give us just a moment and we'll be back with you. I have somebody in a jail window. Can I ask your name? Gentlemen.
Are you addressing me?
Yep. Yes, sir. What's your name?
My name is Stephen Maples, and I don't know why I'm here.
You are not supposed to be here. They have you down for me for some reason, but you are a Judge Olsaver file. So
Is
why
it-
don't you go tell them that they had you in the wrong court, that Judge Olsaver is your judge. All right?
Is he on the bench this morning?
Oh, yeah, he is. They probably called for you and the jail list shows me for you. So they had the wrong person.
It's an imperfect world, Your Honor.
Yes, sir. All right.
Thank you.
All right. So I got Mr. Hodges, I got Mr. Garcia, you're Brian Fry. Ma'am, are you here to watch or do you have a case? Say it again.
Adam Steers.
Okay, so you don't have a case.
No, he's not there.
He's what?
He's not gonna be on there, Adam Steers.
Okay. Yeah. All right. Rhonda, I'm gonna call the jail and get your people. And I have Miss Brenner, so.
Someone sent me, told me to inform you that this is not the place where I'm jailing.
Hey, this is Judge Anslon. So Stephen Maples is actually a Judge Olsaver case.
Oh, come on, miss the paperwork up.
It's okay. It's okay. So
we can copy that.
but I am ready for Israel Vila, Adam Steers, and Jessica Hamilton, and Chad Marvin. So I'm ready for all mine.
You ready for all yours?
Yep.
Let me get it. Yes, I got that one there. 4723.
Israel Vila, Adam Steers, Jessica Hamilton, and then Chad Marvin. I'll take him last.
It's pretty much all yours. You just want to start with.
Yes, sir.
All right, that'll work.
All right, thank you. Bye. Okay, so. And Mr. Malaro. Okay, so Winters. Jennifer Winters, if you'd like to unmute your device and start your video, please. Okay, this is, oh, no. Miss Winters, are you able to start your video? Well, I have the wrong Winters. You are not Miss Winters, so hold on 1 second. All right, so we're gonna pause because you're Mr. Winters and you're Mr. Malaro. So everybody hold on a second. Ms. Rembert, why don't you come on up? Because I know you got a baby out in the car, so let's get you on your way and then we'll take Mr. Hodges. All right, so we're back on the record in the matter of the people of the state of Michigan versus Malika Rembert. Mr. Malaro, you had requested an opportunity to speak with Ms. Rembert. Were you able to accomplish that?
I have, Judge.
All right, and how would you like to proceed today with Ms. Rembert?
Your Honor, we'd like to put a plea on to the following. Ms. Rembert will plead guilty to counts 1 and 2, resisting, obstructing police officers, are both 2-year felonies. Count 3, which is also a resisting, obstructing police officer, a 2-year felony, will be dismissed at sentencing. The prosecutor is recommending a sentence to run concurrent with any sentence related to violation of probation. For the record, I am not aware of Ms. Rembert facing any probation violations. I don't know that she's on felony probation. But if there is, excuse me, a violation, that would run concurrent, whatever sentence there may be. There is no restitution that I can discern from this file. I believe that is the entire plea agreement, Judge.
Ms. Rembert, are you on probation anywhere?
Downstairs.
Downstairs, you're not with me. Good, good. So you understand you may be violated on your probation down in district court, but any sentence they give you, I'll run my sentence with.
Yeah,
All right, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
yes, ma'am.
All right, so Ms. Rember, or Ms. McClure, is that a correct recitation of the plea?
It is.
All right, so Ms. Rember, you heard the plea agreement that was stated on the record. Is it your intention then today to plead guilty to count 1 and count 2, which are police officer assaulting, resisting, and obstructing?
Yes,
You understand both of those carry a maximum penalty of up to 2 years in prison and or up to a $2,000 fine. The felony information, okay, so, or a $2,000 fine. The third count of assaulting, resisting, obstructing will be dismissed. And you understand those are felonies. You'll be placed on felony probation.
yes, ma'am.
Okay, how old are you?
24.
24. Is she eligible for a HIDA?
It would have to be a prosecutor consent HIDA, and I'm not super familiar with the case, but just a quick glance at her criminal history, I don't know that we would consent to it.
She has no prior felonies?
Well, again, I'm not familiar with the case, but in looking at what her prior record is, I do believe she does.
Have you ever been on felony probation?
No.
I don't think she
These are the
has.
only 3 felonies that I have.
Huh?
These are the only 3 felonies.
Yeah, I don't think she's been on felony probation. How old are you again?
24.
All right. Okay, so I
Well,
don't know if
would
you're
ask Mr.
eligible.
Sneed about that. I mean, it's his case, so he would have to
Right.
consent.
Okay, so I don't know if that's relevant to your case or not, but we'll look into it. All right, so are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes.
All right, and you understood, as I already advised, the maximum penalty for this offense could be up to 2 years in prison. But in this case, we'll run it concurrent with any violation you might have in district court if we give you jail.
Yes.
Okay. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Is that correct, Ms. McClure?
That's correct.
Is that correct, far as you're aware, Ms.
Yeah.
Member? Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had if you had had a trial. I'm going to explain those rights to you now to make sure that you understand them. And Ms. Adams, could I get a written copy of the advice of rights for her?
Yes, Judge.
Okay, now, if a guilty, let's see, you have a right to a speedy public trial. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to certain appeal issues that would have been appealable had you been convicted at a jury trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence will be by application for leave to appeal and not by right? So once again, if you had been convicted at trial, you would have had an automatic right to appeal, but by entering a plea, you have to request a right to appeal. Do you understand that?
Yeah.
Do you understand, and this is important, that if the plea is accepted and you engage in any misconduct as defined under Michigan Court Rule 6.310 between now and sentencing, the court will not be bound by your plea. So she's going to hand you an advice of rights form, and I'm going to need you to sign it. And then the signed copy you're going to give back to me, okay? And I think, Ms. Adams, we probably need to get a stack of blank ones in the courtroom. So go ahead and sign that, and then it's all the rights that I'm going through now with you. And then you can kind of read along and keep a copy for your records, all right? I'm gonna need a copy for Mr. Hodges too. Just a stack. Okay, so I've got a signed copy come back to me and that's your copy and it's just going through the rights I'm going through with you now, okay? All right, so if your plea is accepted and you engage in any misconduct between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you won't have a right to withdraw your plea. So this means if you abscond or fail to appear for sentencing, you violate your bond conditions, you commit a new crime, or fail to comply with any orders of the court between here and now, I'm not bound by the plea agreement. Do you understand that? Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I'm giving to you?
No.
All right. How do you wish to plead to the charge that on or about April 17th of 2024 in the city of Adrian in the county of Lenawee, that under count 1, you committed the offense, police officer assaulting, resisting, and obstructing? And how do you plead under count 2 to the offense, police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro
I am not aware of any, Your Honor.
and Ms. McClure?
None, Your Honor.
Right. So other than the agreements we've talked about on the record, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
All right. So, Ms. Rember, on April 17th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
All right. So at some point you came in contact with some Adrian police officers. Is that correct?
Yes.
And one of them was an Adrian Robinson and the other was a Brian Mullen. Is that right?
Well, yeah, there's about, yeah, that's right.
Okay. And Adrian Robinson, do you know who he is?
Yeah.
Okay. So at some point, did you walk away from him, run away from him, lie to him, pull your hands away from a handcuff? Like, what did you do to resist arrest?
He tried to take a bottle out of my hand and I wouldn't let him. And I made them drag me out of the house because I didn't want to get in the police car.
Okay. And so Officer Mullen was also one that asked you to leave the house and you wouldn't leave, so they, okay. Are you satisfied, Ms. McClure?
Satisfied, Your Honor.
All right. Has court complied with MCR 6.302 B, C, and D? Mr. Malaro?
Court is.
Ms. McClure?
It has.
All right, Ms. Adams, I'll need a sentencing notice for her as well. I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, other than I would sentence concurrent any sentence there is. So, Ms. Rember, I'm going to refer this matter to the Circuit Court Probation Department. Before you leave today, I need you to check in across the hall, all right? And they're going to get your name and your contact information. They're going to set up a time for you to come back and meet with them. It's very important that you make it back for that meeting. If there's an emergency and you can't make it, you need to call and reschedule it right away, okay? When you meet with them, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. I'm going to need you to call Mr. Malaro about a week or two before sentencing and review that with him, okay? And then I'm going to set sentencing for August 22nd at 8:15 in the morning. So I'm going to need you to come in person. So August 22nd at 8:15. And if you want to have a seat right behind you real quick, we'll get you a notice of hearing for sentencing, okay? And then once you get that, check in across the hall. They'll give you a packet to fill out too. Make sure you fill it out and drop it back off, all right? And then, so we'll get you that notice and then you can check in across the hall and be on your way, all right? Thank you. Mr. Hodges, you want to come back up? Mr. Murphy, in the matter of people of the state of Michigan versus Antonio Hodges, file number 25-22119FH. So, Mr. Murphy, how do you wish to proceed today?
Your Honor, the offer from the prosecution would be for Mr. Hodges to plead to count 1 with no habitual offender status and an agreement that there will be no jail in the matter at the time of sentencing. At this time, Mr. Hodges does wish to accept that offer and again, plead guilty to count 1, resisting and opposing an officer.
Okay. So Ms. Adams, I'm gonna need some, do we have advice to rights? Awesome. So we're gonna hand down to you two copies of your advice of rights, okay? There's a tissue there if you wanna spit out your gum. It's okay. And a pen, and if you could sign one just to acknowledge you received the other one. Ms. Rembert, just step in across the hall, okay? Thank you. All right, so Miss McClure, is that a correct recitation of the plea? Who's my prosecutor?
It's Mr. Bayonetto. I don't know where, I don't see him here.
I don't either. I got one prosecutor. Mr. McCready, do you want, or there's Miss McClure. Will somebody log on? Or start your video, please? All right. So I don't know, Mr. McCready, if you're able to verify the plea that I just, oh wait, I got a plea agreement form, so that helps. But Mr. McCready, if you can keep your video on. So raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so I need you to speak up a little bit. You're soft spoken. Can you state your full name for the record?
Antonio Demetrius Hodges.
All right, so Mr. Hodges, I received a plea agreement form that states that the offer is that you will plead guilty to count 1 as charged, which is police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine, with a sentencing agreement that there would be no upfront jail and that your habitual offender 4th offense notice would be dismissed. Is that your understanding of the plea?
Yes, ma'am.
All right. So is it your intention then today to plead guilty to that count?
Yes, ma'am.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. McCready?
As far as I know, that's correct, yes.
All right, Mr. Murphy
That's correct, Your Honor.
and Mr. Hodges, is that correct as far as you're aware?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial, and I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Hodges, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, Your Honor.
You understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right. Do you understand that?
Yes, ma'am.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have the right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. And Ms. Adams, I'll set this for July 22nd or August 22nd as well for sentencing. So if you want to get a notice started, you can. So if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just given to you?
No, ma'am.
All right, how do you wish to plead to the charge that on or about December 23rd of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense
24, December 23rd, 24.
of 24, I'm sorry, wrong year, that you did commit the offense of police officer assaulting, resisting, and obstructing, guilty or not guilty?
Guilty.
All right, has anybody made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. McCready?
No, not your honor.
Mr. Murphy?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so sir, on December 23rd of 2024, we're in the city of Adrian in the county of Lenawee.
Ma'am.
Did you come in contact with an Adrian police officer named Colin Castleberry?
Yes, ma'am.
And at some point, did you assault him or run away from him or walk away from him or not comply with what he asked you to do?
Not right.
Okay, can you tell me what you did?
He asked me to walk and I get away, just drop down, get away.
Okay, so you disobeyed an order. Okay. Mr. McCready, are you satisfied?
People are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. McCready?
Yes.
Mr. Murphy?
Yes, Your Honor, it has.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set sentencing for August 22nd at 8:15 in the morning. Do you want to appear in person or via Zoom? In person, all right. And so, Mr. Hedges, I'm going to ask you when we're done here to step across the hall to the probation department and check in. They'll give you a packet to fill out. You got to make sure you fill it out and hand it back in. And they'll give you a time either today or when they call you to come in and meet with them, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll get it to your attorney a couple weeks in advance. Make sure you reach out to him before the day of sentencing to review that. And then we'll see you back here on August 22nd at 8:15 in person. Have a seat right behind you and my staff will bring in a notice of hearing for you, okay?
Mr. Hodges, could you contact my office after you have that interview with the probation department, just so we know the time frame on that, please?
Yeah.
Thank you.
You want some files? We have some files. There's the. All right, so let me get organized. All right, so Mr. Malaro, well. Is Justin Evans in my waiting room? Yeah. Hold on, Mr. Malaro was here first. I'm still gonna finish him up first. Dustin Evans, if you could start your video and mute your device or unmute your device, please. Wait, I might have lost Mr.
Can you hear me, ma'am?
I can, but I think I lost Mr. Malaro.
Oh,
I'm
okay.
looking. I don't see him. All right, so I'm gonna change your screen name real quick. I lost him because I delayed. And I'm going to pop you back in the waiting room because I don't see him in my waiting room.
Okay, yes, ma'am.
So I'm sorry about that.
Okay.
I
So
still
I'm
see
gonna
Mr.
add your
Malaro on my
last
screen.
name.
Judge,
Okay.
I'm
I'm gonna
here.
add,
Judge, Mr. Malaro's here.
where is he?
I don't know where I'm at, but I'm here. There I am.
Oh, you have no video. That's why. I'm sorry.
There I
So
am.
this is in the matter of the people of the state of Michigan versus Dustin Lee Evans, file number 25-22262FH. We also have in the matter of Zara Evans versus Dustin Evans. I have Zara Evans in the waiting room too. Let me bring him in. Her in or all right, so I have Mr. Malaro appearing on behalf of Mr. Evans, and my prosecutor is Dave McCready. I also have Darren Coast here from Pretrial Services. Mr. Coast provided a letter dated July 7 that states Mr. Evans continues to be monitored by GPS tether. To date, I have not received any violation notices either or from the tether company. Have not fielded any complaints from Zara Evans, the victim in this case. So, Mr. Malaro, how would you like to proceed today?
Judge, I believe we have a plea agreement, but I don't see the details in my notes. If Mr. McCready could review it, that'd be great.
Yeah, let me pull it up. So the offer is that he would plead guilty to count 2 aggravated stalking. That we would have a sentence agreement of 5 years probation with 1 year in Lenawee County Jail, but that would be suspended. We would, on our part, dismiss count 1, the home invasion. And the additional terms and conditions of the plea would be a strict no contact order with Zara Evans. They are in the process of a divorce. I'm not sure where they are in that process, but there may be contact through a court of competent jurisdiction by order of that court. But other than that, there's going to be no contact with her person, with any of her property, including her home, and no contact with her military command, which we have reason to believe he's tried to contact and get her in trouble. So in addition, he must enroll in Veterans Treatment Court, which would include applying for Veterans Administration care, undergoing a substance abuse assessment and substance abuse testing, that he would join and successfully complete an interpersonal violence or domestic violence group program, and that he would follow all treatment recommendations.
All right, so Mr. Malaro, I'll probably need a plea agreement form on that one because it's pretty lengthy. How does your client wish to proceed today? I believe I heard him saying, but I'm not sure if that was him or not.
That wasn't me, ma'am.
Oh,
Okay,
yeah, I was gonna
okay.
say, Judge,
I heard somebody, so I didn't know who it was.
right, we have spoken, and I believe that is our plea agreement, and I believe Mr. Evans is willing to enter into that plea agreement.
Okay, so Mr. Evans, it's quite a lengthy plea agreement. Do you understand all the terms?
Yes, ma'am. Just from my understanding, the probation was through the Veterans Court, is what?
Right, so it requires a 5-year probation term. Veterans Court is like a 2.5-year program. So you would have to, has he been admitted to Veterans Court, Mr. Malone?
It's my understanding, Judge, yes, he has been accepted to Veterans Court.
Okay.
Yeah, that is correct,
So,
Your Honor.
Yep, you would have to enter and complete that program as a term of the plea, but you would have probation for a period of time after that as well, okay?
Okay, yes, ma'am.
All right, so Mr. Evans, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, yes, ma'am.
So, Mr. Evans, you've heard the statement of the prosecutor and your attorney. Is it your intention to plead guilty to count 2 aggravated stalking, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine and no less than 5 years probation? And they're asking for the 5 years, not more probation. So is it your intention to plead guilty to that count?
Yes, ma'am.
Are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro
Yes, that is correct, Judge.
and Mr. McCready?
Correct.
Now, Mr. Evans, we will be mailing to you 2 copies of your advice of rights if you haven't already received them. One of them I'm going to need you to sign and date. You can bring it back the day of sentencing, or you can drop it off when you come to the probation department, all right?
Yes, ma'am.
Okay, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor in court agrees, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Evans?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation. You will not have the right to withdraw your plea. Misconduct as defined to include but is not limited to absconding, failing to appear for sentencing, violating your terms of conditions of bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So, for example, if you were to violate the PPO or violate bond conditions, I could sentence you to prison and you wouldn't be able to withdraw your plea. Do you understand that?
Yes, ma'am. I understand.
Okay, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All
I do not know.
right, so how do you wish to plead to the charge that on or about April 18 of 2025 in Raisin Township in the county of Lenawee, that you did commit the offense of stalking aggravated? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, just other than the plea agreement, I guess would be.
Okay, yeah. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements, other than the plea bargain, to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. McCready?
No.
All right. Has your attorney promised, well, hold on. I'm going to ask, it's kind of the same question. Has your attorney promised you any other particular sentence or estimated what your sentence will be other than the agreement?
No, ma'am.
And it's your own choice to plead guilty?
Yes, ma'am.
All right. So, Mr. Evans, on April 18 of 2025, were you in Raisin Township in the county of Lenawee?
Yes, ma'am.
All right. And Zara Evans is your current wife. Is that correct?
Correct. Yes, ma'am.
And did you, did you harass her repeatedly?
Yes.
Mr. Malaro, you wanna
Okay,
voir dire
yeah.
here?
Sure. So, Mr. Evans, you were separated from Zaret Evans at the time,
Yes, sir.
and she had a PPO against you?
Yes, sir.
And part of that PPO is that you weren't supposed to be at her house?
Correct. Yes, sir.
And while she was out, I think she was on a military base, you went into the home
Yes, sir.
and you took photos or photos with your phone of your joint child?
No, I didn't take photos, but I went and laid with them. Yes, sir.
Okay, and you let her know that that's what you were doing?
Yes, sir.
And you agree that a reasonable person with a protection order against you would have felt frightened by that behavior?
Yes, sir.
And you agree, in fact, that she was frightened by that behavior?
Yes, sir.
You also contacted her, or did you not just have a contact with her superior officer?
When she called me.
Okay. And you
Yes,
know you were in violation of your protection order when this occurred?
Yes, sir.
Is the court and the state satisfied?
Mr. McCready?
I would just want to know that there have been other instances of unwanted contact by the defendant towards Zaret.
Yeah, Mr. Evans, do you agree that you had additional contact with Miss Evans, your estranged wife that was unwanted?
Yes, sir.
And you agree that would rise to the level of a course of conduct?
Yes, sir.
People are
Now is the
satisfied.
state satisfied?
Has the court complied with MCR 6.302B, C, and D? Mr. Malaro?
I believe the court has, Your Honor.
Mr. McCready, anything
Yes.
further? All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew plea. I'm going to refer this matter to the Circuit Court Probation Department for a pre-sentence investigation. I will set sentencing for August 22nd at 8:15 in the morning. Mr. Malaro, that will be in person because of the plea agreement. So, Mr. Evans, I'm going to pop you in a quick breakout room with Chris Jones so that he can get your contact information. He is a Circuit Court probation officer. He'll give you instructions on picking up a packet, filling out information, and reporting for an interview. When you do meet with them, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide that to Mr. Malaro. Please contact him in advance of sentencing to review that. And then we will see you back here on August 22nd at 8:15. So go ahead and join that breakout room with Mr. Jones. Thank you.
Yes, ma'am. Thank you.
Thank you, Judge.
And I'll just carry the PPO violation to sentencing date.
Thank you, Mr.
Okay.
McCready.
Thank you.
Hold on, Mr. Malaro, you have one more, and then I'm gonna move over to Miss Underwood and okay, hold on. Miss Brenner, let me take care of Miss Brenner and Miss Underwood. Mr. Steers, where you at? There you are. I wanna get Miss Brenner on her way to her next court. So this is in the matter of the people of the state of Michigan versus Adam Christopher Steers, file number 25-22236FH. I have Sarah Brenner appearing on behalf of the Attorney General, and I have Rhonda Underwood appearing on behalf of Mr. Steers. This is the date and time set for a pretrial conference. Ms. Underwood, how would you like to proceed on behalf of Mr. Steers?
Your Honor, I've spoken with Mr. Steers and with Ms. Brenner. The offer in this matter, Your Honor, is Mr. Steers will plead guilty to count 1. Count 2 will be dismissed. I don't believe there are any habituals. As pursuant to the plea, Your Honor, Mr. Steers will be given a PR bond at the time of plea, Your Honor, to go out and get a job prior to sentencing, Your Honor, in this matter. So if Mr. Steers is paying, there will be no further upfront jail, Your Honor.
Is that a correct recitation of the plea, Ms. Brenner?
Correct, Your Honor. But just to clarify too, he has a current obligation on another case in a different county. And so he needs to make sure that payments are coming to the Lenawee County case for the no jail recommendation from me.
So Mr. Steers, that means that if you take the plea and you get released, you're going to have to make your payments in person here, okay?
Yes, Your Honor.
All right, so Mr. Steers, you've heard the plea agreement that's been offered by the Attorney General. Do you wish to avail yourself of this plea bargain?
I
Yes,
plead
he
guilty.
does, Your Honor. And I believe we made sure about a vice of rights yesterday or the day before.
Did you get your advice of rights, Mr. Steers?
Yes, Your Honor, I did.
Did you read through it? You understand them?
Yes. Yep.
I'm still going to go through them again, and I apologize to everybody. For some reason, we're getting a lot of pleas today, so it's taking a little bit longer, and I appreciate your patience. All right, so Mr. Steers, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Now, Mr. Steers, you've heard the statement of your attorney and the Attorney General. Is it your intention to plead guilty to count 1, child support failing to pay, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine? So is it your intention to plead guilty to that count?
Yes, Your Honor.
Right. Do you understand the count 2, child support failing to pay, will be dismissed and you'll receive a PR bond today? And then you got to hustle and get a job or two and start making payments. And if you're making payments, so you got to pay the amount that's, is this arrearages only or a charging?
Arrearages only, Your Honor.
All right, so you're going to have to be making payments on this, but you also need to be making your other child support payment too. Do you understand that?
Yes, I do, Your Honor.
And as long as you're paying on this arrearage, what are you asking? What is his other obligation, Ms. Brenner?
Let me check, Judge.
Your Honor,
it's
he's on probation.
It's $337 a month on his other case, Judge.
So you're going to have to be paying your $337 a month on your other case. And what are you asking for him to make on this one? 100, 150?
Yeah, that would be reasonable, I think.
All right. So then, yeah, if you can pay $100 or $150 every month on this case, you'll have to come in person and do it. Then there'll be no upfront jail. Do you understand that?
Yes, I do, Your Honor.
Okay. Let me see. I don't know if I asked you, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I do, Your Honor.
Okay, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Ms. Brenner?
That's correct, Your Honor.
And Mr. Steers, is that correct as far as you're aware?
Yes, Your Honor, it is.
All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding, failure to appear at sentencing, violating terms or conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen, so if you fail to make your $100, $150 a month payment, then the sentencing agreement goes out the window. Do you understand that?
Yes, I do, Your Honor.
All right, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, how do you plead to the charge that on or about the time period of January 1 of 2021 through February 28 of 2022 in the city of Adrian in the county of Lenawee, that you failed to pay child support up to the amount ordered on a monthly basis? Guilty or not guilty?
Guilty, Your Honor.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
You understand if I accept this plea, you will be giving up any, I'm sorry, what did you say, Mr. Steers? I'm sorry.
No, Your Honor.
Okay. Let's see. Do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor, I do.
Is the prosecutor or the attorney general or the defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Brenner?
Your Honor.
And Ms. Underwood?
No, Your Honor.
Is it your own choice to plead guilty, Mr. Steers?
Yes, Your Honor, it is.
All right, so, Mr. Steers, you have a child with a Randy Snyder, is that correct?
Yes, Your Honor, it is.
All right, and through the courts, there was an order for you to pay child support for that child, is that correct?
Yes, it is.
And there was a monthly amount you were ordered to pay, and during the time period of January 1 of 2021 through February 8th of 2022, did you make your monthly payment up to the amount ordered?
At that time, I didn't. So no, I didn't.
Okay. Ms. Brenner, are you satisfied?
Yes, Your Honor.
All right, has court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Ms. Brenner?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the Attorney General's office, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew agreement. I'm going to refer this matter to the probation department for a pre-sentence investigation. So Mr. Steers, a couple things. I'm going to set sentencing for August 22nd at 8:15 in the morning.
Your
I'm
Honor,
sorry.
can I suggest
Yes.
that we set sentencing for maybe 60 days out, giving Mr. Steers a little more time to acclimate after getting out of jail and get his job and get settled?
So Ms. Adams, could I get a sentencing date towards the end of September?
Yes. September 19th.
All right, so I'm going to set sentencing for September 19th at 8:15 in the morning, Mr. Steers. So Ms. Brenner, if he is making all of his payments in person or making all of his payments, would it be all right if he appeared via Zoom?
Fine, Judge.
All right, so Mr. Steers, if you get out.
We didn't pick up Ms. Brenner.
Can you repeat that again, Ms. Brenner?
That's fine, Judge.
All right, so Mr. Steers, obviously it's gonna take you like a month to get a job. I don't care, rake leaves, weed gardens, wash dishes, whatever. Make these payments, but as long as, so it's July, so August, September, you know, we should have, let's move it out to October to give them a little bit more time. Ms. Adams, I apologize. Can I get an October date?
October 24.
All right, I'm gonna move it out even further. So as long as you make that $150 a month payment, after starting in like August, September, October, you can appear via Zoom for sentencing if you want. But if you haven't made those payments or you missed a payment, you better come in person so we can have a further discussion, all right?
I understand, Your Honor.
All right, so I'm gonna release you on a PR bond. So there's nothing else holding you in jail, is there?
No.
Okay, when you get out of jail today, I need you to come across the street to the courthouse. I need you to go to the 3rd floor and check in at the probation department. They're gonna give you a packet to fill out, and they're gonna give you a time or get your contact information and give you a time to come in and do an interview. When you do that interview, I need you to be truthful with them about your background, the events that occurred, and they will prepare a pre-sentence report. About a week or 2 before sentencing, you need to reach out and talk to Ms. Underwood and go through that pre-sentence report. And then we will see you back on October 24 at 8:15 in the morning for sentencing. Like I said, if you made August, September, October payment, go ahead and zoom in so you don't miss work. If you didn't, you need to come see me, all right?
I understand, Your Honor. Thank you.
All right, probation department's closed from 12 to 1. So if you get out during the lunch hour, just wait till they open back up at 1, okay?
Okay, thank you, Your Honor.
You're welcome, 3rd floor probation. Thank you.
All right, thank you.
All right, I'm almost done with Mr. Malaro. So Malaro, you have one more, McGowan. Okay. All right, Mr. McGowan, all right, this is in the matter of the people of the state of Michigan versus Jeffrey Steele McGowan. File number 25-22211FH. I have Salvatore Malaro appearing on behalf of Mr. McGowan, and I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Malaro, how would you like to proceed?
Your Honor,
Your
after
Honor,
talking to the.
Could I
All right,
interject?
go ahead, Ms. McClure.
Sure.
Okay. So there was an agreement in this case that Mr. McGowan, if he were to take steps to get his concealed pistol license, including taking the class and getting ready to fill out his application, that this case would be dismissed so that he can apply to get his concealed pistol license. So Mr. Malaro has provided to our office the certificate of CPL class completion. So I am prepared to file a noli pros with 2 things to place on the record. One, that if he does not provide proof of his CPL once it is obtained, that the case will be reissued. And 2, that he is forfeiting the firearm involved in this case.
If he doesn't complete that.
No, he is forfeiting the firearm regardless,
Oh.
but if he does not provide proof of his CPL, we would reissue the charges.
All right, does that sound right, Mr. Malaro?
It sounds correct, Judge.
Do you understand all of that, Mr. McGowan?
Yes, Your Honor.
Okay, all
In
right.
that case,
so
Judge, then I will forward the noli pros to your office.
Okay, and I will sign that upon presentation. Thank you.
Thank you.
I'm sorry, Mr. Fry. We've had a lot of pleas this
So,
morning,
Mr.
which is great.
McGowan, send me that proof when you get it, okay?
Yes, thank you.
And I know it takes some time. I mean, I think it could take up to, 90 days or so. So
Yes,
I know it takes some time. And just give it a few days for the noli pros to go through before you go get your fingerprints done.
Yes, ma'am. Thank you so much.
All right. Mr. McManus, I know you're there. I'm sorry, I gotta get my public defenders moving so they can head to the next court. So I'm gonna take the Winters files, and I believe that's the last one Mr. Malaro has, but Mr. Mott is on the other one. So I should have Jennifer Winters and David Winters go ahead and start your audio, and then I need to see your face. Thank you. All right, I got Mr. Winters and Jennifer Winters. Excellent. So this is in the matter of the people of the state of Michigan versus David Javon Winters, file number 25-22200FH. On this file, I have Salvatore Malaro appearing on behalf of David Winters, and I have Phoebe McClure appearing on behalf of the people. And then on the matter of the people of the state of Michigan versus Jennifer LaShawn Winters, file number 25-22201FH. I have Katerina Dumont and Phoebe McClure. I called them because I believe they're co-defendants. So, Mr. Malaro, how do you wish to proceed today with Mr. Winters?
Your Honor, with respect to Mr. Winters, I believe there's been an agreement reached whereby Mr. Winters will plead guilty to count 2, tampering with evidence. Counts 1 and 3 would be dismissed, and the court will sentence under MCL 771.1. And although it's not my client, and I did not have a say in the negotiation, upon that, the charges against Ms. Winters would be dismissed.
Okay, does that sound right, Ms. Dumont?
Yes, Your Honor.
Does that sound correct, Ms. McClure?
I'm still trying to catch up on my notes here because it's not my case.
I do
Judge,
have notes in my file that say that if he pleads guilty to count 2, he would be sentenced under 771.1, restitution in the amount of $1,200, and the charges would be null pros against Miss Winters. I do have that.
Okay, that's fine.
I'm sorry about the restitution. Yes, there's restitution, Judge.
So, Ms. McClure, did you find what you needed?
Yeah, I would trust the court and Mr. Malaro. The notes don't make sense to me, so I'm just going to defer to what you guys have.
Okay, well, we'll thank Mr. Sneed for that, right? Okay, so, Mr. Winters, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, so Mr. Winters, are you with Miss Winters?
Yeah, doing the same myself.
No, it's okay. So Miss Winters, I don't care if you guys are on the same device.
Oh, okay.
That's fine, but I've got to be able to hear him, not you. So go ahead and you can go sit with him, but I don't need to see your face anymore. I don't mind seeing your face, but I don't need to right now. I need to hear Mr. Winters. So, Mr. Winters, she can go ahead and disconnect and come sit by you if she'd like. And then I need you to unmute, Mr. Winters. There you go. Oh.
Can you hear me?
Okay, yes, perfect. All right. So, Mr. Winters, is it your intention to accept the plea offer today?
Yes, it is.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so Mr. Winters, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 2, tampering with evidence, which carries a maximum penalty of up to 4 years in prison and or a $5,000 fine? Count 1 and 3 would be dismissed at the time of sentencing. So is it your intention to plead guilty to that offense?
Yes, ma'am.
Now you understand restitution will be set in the amount of $1,200. And if you successfully complete your bond conditions and probation, you would be sentenced under 771.1, which is, let me get back there. Which means that, what is the, Mr. Malaro, that would be a delay,
So, Judge,
correct?
as I understand it, Judge, once when we come back to court, are you satisfied whatever conditions have been imposed? This matter would be a non-public conviction, so it would not be accessible to the public.
Okay. So,
Yeah.
Mr. Winters, do you understand that? Would it be
I
a
do.
1-year delay?
The court, as I understand the reading of the statute, it can be up to 1 year, but does not have to be.
All right. And Ms. McClure, are there any notes on this from Mr. Sneed about?
No.
Okay, okay. All right. So Mr. Winters, okay. So do you need time to talk to somebody, Mr. Winters?
Oh no, I'm coherent with what's going on. I understand, and we talked about
Okay,
everything.
so you understand, yes, so you understand there'll be a delay. If you successfully complete the terms, then this offense will be non-public, so it won't show as a public conviction. Do you understand that?
Understood.
Okay, and you wish to enter this plea?
I do.
Okay, so you understand the maximum penalty could be up to 4 years in prison. You understand that, correct?
I do.
All right, and other than the agreement that was placed on the record, has there been anything else discussed with you, Mr. Winters?
No.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, sir, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that, sir?
Yes, I understand. I'm waiving my rights.
Okay, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Correct.
And do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Do you understand that?
I do.
Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Winters?
No, I do not.
All right. How do you plead to the charge that on or about the time period of September 30th of 2024 through October 28th of 2024 that you did commit the offense of tampering with evidence? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty?
No, Your Honor.
Yes.
No.
Okay.
No, Judge.
Thank you. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Winters?
He have not.
Okay. Is it your own choice to plead guilty?
Yes, I am.
So hold on one second.
It's hard to understand that last one.
I can't hear you.
It was just hard to get that last one, but we're.
All right, so, Mr. Winters, as we keep going, you gotta speak up a little bit.
Oh, I'm sorry about that.
No, you're fine, you're fine. Hold on, I'm gonna look up something. Hold on 1 second. All right, so. All right, so here's my thing, Ms. McClure and Mr. Malaro. Under MCL 771.1, I can delay a sentence after a plea of guilty. And then I can place him on probation for a period of time. If he successfully completes probation, the case may be dismissed. That's 771.1.
That is true.
So it doesn't become, well, I mean, it doesn't just become non-public, the case gets nullified.
Right.
But well, it says may get dismissed, Judge, and I would certainly ask for dismissal if he successfully completes whatever terms you set, but it is not a shall be dismissed.
Well,
But I
typically,
believe it is a shall become non-public either way.
Okay, I just want to make sure, okay.
say, I don't know that the,
Hold on, I'm not picking you both up. Go finish that, Mr. Malaro.
I would certainly request of this court, if Mr. Winters completes what's required, I would request that the matter be dismissed. I believe it's within the court's discretion.
So, Ms. McClure, I guess I could delay the sentencing 12 months. We can monitor him on probation with Mr. Coast. If he pays his restitution full and complies with everything when we come back for sentencing, we can have that discussion on the record. Would that satisfy the people?
so typically what we do is when they are placed on probation, we get, and district court monitors this and has done it before. They send notice to our office that all requirements are complete and it's been the 12 months. And then we just file the noli pros without having to come back into court. And
I'm okay with that too. I'm
but
fine with that.
the charging segment and if there's an arrest segment in the CCH, that does not become non-public. I mean, I think you can motion for it to be through the state police, but it doesn't automatically become non-public, and I don't know that we even have control over that, but it will show as a dismissed case.
Okay. All right. I'm sorry, Mr. Winters. I just want to make sure we're all on the same page. So you understand all of that, right?
I appreciate the brainstorming. Thank you.
Okay, thank you. All right, so I think I ended as at your own choice to plead guilty, right? All right, so Mr. Winters, on or about the time period of September 30th, 2024 through October 28th of 2024, we in Clinton Township in the county of Lenawee?
Correct.
Okay, and at that time, did you, Mr. Malaro, it doesn't really clearly state. Why don't you
Yeah,
volunteer on this one?
I can do it, Judge. Judge, I think it's Raisin Township. If I thought
Well, Clinton Township is in like Macomb County, so it's either, I don't know, so it's
No,
Raisin Township?
it's Raisin Township, Judge. So, Mr. Winters, the dates between September 30th and October 28th of last year, you were in Raisin Township in the county of Lenawee, state of Michigan. Is that a correct statement?
Correct. Correct.
Okay. And you and your wife owned a cleaning company?
Correct.
And you took over a cleaning contract whereupon for I think it was a car dealership.
Correct.
And somehow the company from which you took over that contract had left their floor scrubber at the business.
Mm-hmm.
Is that, you gotta say yes or no?
Yes. I'm sorry. Yes.
Okay. Somehow that floor scrubber ended up in your garage.
Correct.
Then the police showed up looking for that floor scrubber. And before they came back with a warrant, you moved that floor scrubber to the neighbors.
Correct.
And you agree that you did that with an effort to remove that evidence so that the police would not find it in your garage.
Correct.
Is the state and the court satisfied?
Satisfied, Your Honor.
All right, has the court complied with MCR 6.302, B, C, and D? Mr. Malaro,
I believe the court has.
Ms. McClure?
It has.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. So hold on one second. So it's July now. I am going to set sentencing for July 11, or no, June 11 of 2026. So June 11 of 2026 at 8:15 in the morning. So that's the delayed part of it. And so what I'm going to have you do is report to actually Darren Coast. That's how we do these. And Darren Coast is my pretrial services coordinator. Miss Adams, could you see if Mr. Coast can log on? Have you had any interactions with them for bond conditions, Mr. Winters?
I have not.
All right, so I'm going to put you in a breakout room here today, though, with Mr. Jones and Mr. Coast. Mr. Jones is from the Michigan Department of Corrections, and you're going to need to, you're still living in Adrian?
I am.
Okay, so you're going to meet with him. He's going to get your contact information. They're going to set up a time for you to come in and meet with the probation department, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Malaro. He'll provide a copy to you. Make sure you meet with them before sentencing, which is 11 months from now. During that term of bond, basically prior to sentencing, you're going to need to pay the restitution in full, along with your court costs and otherwise. Hold on, let me see if I got Mr. Coast back yet.
Can I ask what's the restitution?
The restitution I have is $1,200.
And what is that for? From what?
I'm
There's
assuming
damage to the scrubber, supposedly.
I sent you information on that, Malara.
All right, so that might be a further discussion Mr. Malaro has to have with the prosecutor on this file. All right, so Mr. Coast, this is Mr. David Winters. He entered a delayed plea today. I'm setting sentencing in this matter for June 11 of 26. I'm going to assess the $750 in court costs, $130 crime victim rights fee, $68 in state costs, and $30 per month supervision fee. Mr. Winters, those are the typical fines and costs. You'll have 11 months to pay those off through Mr. Coast because of the delayed sentence. I'm not sentencing you until June of next year, and if you've been in compliance with everything, your attorney at that time will move for a dismissal or the prosecutor will grant that. Do you understand that?
Understand.
Okay, and then if I'm going to order the restitution of $1,200, but it sounds like Mr. Malaro and Mr. Sneed need to meet on that and come to some resolution on that. So that can be determined or evaluated. So I'm going to open up on, and then Mr. Winters, that sentencing would be in person if we even have it. Like I said, if you complied with everything, it may very well get dismissed before that date. So I'm going to open up a breakout room and I'm going to, oh, you're welcome. I'm going to assign Mr. Winters. Mr. Malaro, do you want to go in or no?
Yeah, I probably should.
All right, so I'm going to assign, let me find Sam Malaro. Chris Jones, who is Michigan Department of Corrections Probation Officer, Mr. Winters. Darren Coast, who is my pretrial services coordinator, he will be monitoring you. And then Mr. Mallow and you to a breakout room. Go ahead and join that breakout room.
Thank you.
Thank you, and good luck to you, Mr. Winters. I think that takes care of Sam Malaro, Mr. Mont, that takes care of you. Hold on, Ms. Underwood, I see you, but I'm gonna take care of Mr. McManus. I always like.
We want, Your Honor, do we want to set another date in Ms. Winters' case, or?
Oh, yeah, we'll set it for the same date. So in Jennifer Winters' file, we'll set it for a pre-trial on June 11 of 26 at 8:15.
Thank you.
Can you do the stip in order to adjourn?
I was gonna say, Mr.
Yes.
Mon, if you wanna just email Mr. Sneed and let him know that the plea was entered, he may just file the nollie pros.
You know, Ms. McClure, you're really faint. We're not picking you up well at all.
Oh. I was just letting Ms. Dumont know if she wants to email Mr. Sneed that the plea has been entered, he may just file the dismissal.
Okay.
I'll do that too. Thank you.
Okay, Andrew Wright, in the matter of the people of the state of Michigan versus Andrew Gordon Wright, file number 25-22169FH. I have Martin McManus appearing on behalf of Mr. Wright, and I have Phoebe McClure appearing on behalf of the people. This is the date and time scheduled for a second pretrial in this matter. Mr. McManus, how do you wish to proceed today?
Thank you very much, Your Honor. We have continuing negotiations. We believe we're getting close to this matter. We know this has been kicked for a couple times. However, from this incident, my client was shot, and there were some medical situations that caused for the delay. So we're requesting one final pretrial for August 7th or August 14th.
So those are Thursdays.
Oh, I'm sorry.
So I can do August 13.
If you do the, I can do August 6th or the 20th, August 20th, if that's available, Your Honor.
No, I can do August 6th at 8:15 in the morning.
Okay, that's fine. Thank you, Your Honor.
All right, so Mr. Wright, your next pretrial will be August 6th at 8:15 in the morning, same Zoom number. And Mr. McManus, if you can do the step in order to adjourn. Ms. McClure, can he sign your name with permission?
No objection.
Okay, so, all right. Ms. Underwood, are you done in front of Judge Olsaver?
I don't think so, Your Honor.
Okay. I'm sorry. Are you getting a date or a plea?
One of each.
Really? On him?
Not on him, but I have
What are you doing on him?
getting a date.
Why'd you come up and let him? Well, let's see. Here is Noah. All right, this is in the matter of the people of the state of Michigan versus Noah Michael Finley, file number 24-21954FH. I have Brian Fry appearing on behalf of Mr. Finley. Ms. Adams, I'm going to need a pretrial notice on this because Mr. Finley is here in person. So, Mr. Fry, you're asking for an adjournment on this. How far out?
If I could get a pretrial in September, Your Honor.
How about September 17?
That works.
All right, so we will set this over to September 17 at 8:30 in the morning. Mr. Finley, you're gonna stay right there and my assistant's gonna bring you a notice of hearing, okay? All right.
Your
Thank you,
Honor,
Mr. Fry.
Your Honor.
Oh, Mr. Wright, you're all set.
All right,
Did you
thank
go? Okay,
Have a
thank
good
you.
day. Bye.
You too, bye-bye. All right, so, okay, that takes care of him. So my assistant will bring you a notice. All right, Rhonda Underwood, Jessica Hamilton.
Your Honor, could we take care of Mr. Vila first?
Mr. Vila, so this is in the matter of the people of the state of Michigan versus Israel Vila Jr., file number 25-2210FH. I have Rhonda Underwood appearing on behalf of Mr. Vila, and I have Phoebe McClure appearing on behalf of the people. this is the date and time set for a pre-trial conference in this matter. Ms. Underwood, how would you like to proceed?
First of all, Your Honor, Mr. Vila's cases are being reassigned. We are in the process of doing that.
Okay.
Your Honor, Mr. Vila has a preliminary exam scheduled for next Tuesday. We would ask that a pretrial on this matter be scheduled sometime after that, perhaps in August.
August 13th.
Judge Angelo, can we push it off further than that?
You want it further than that?
Yeah, because I'm in the process of trying to figure out some stuff myself due to the bond issue. Last time when I tried to pay.
Okay, do you want the end of August or the first week of September?
Let's do the first week of September, please.
All right, so I'll set it out to September 3rd at 8:30 in the morning. And Ms. Underwood, can you do the stip in order to adjourn?
I will do the stip in order.
All right, and Ms. McClure, can she sign your name with permission?
She can, but who is the case getting reassigned to?
Through the PD's office? I don't know.
That has yet to be determined, Ms. McClure. I apologize. I will let you or they will let you and Ms. Arnold know.
Just Miss Arnold, it's her cases. I just didn't know if it was staying with the PDs or somewhere else.
At this time, it is staying with the PD's office. Mr. Vela has expressed his desire to retain counsel, but I don't know if he's going to do that.
All right, so Mr. Vila, we will see you back on September 3rd at 8:30. You're all set. Thank you.
Judge, may I take leave of your court
Yeah, I think I'm done with you. Be gone with you.
for now? Thank you.
All right, thanks. All
Your
right,
Honor, may I have
so
a
Mr.
breakout with Ms. Hamilton.
Yep, this is in the matter of the people of the state of Michigan versus Jessica Charisse Hamilton, file number 20-19941 and 20-19943 FH. These are yours. Oh, yeah, these are Bob's. So I have Brenda Underwood appearing on behalf of Miss Hamilton, and Mr. Fry was just here, Mr. Marvin. So let me see if he's next door. Do you want to say Brian?
Yes.
Fry went next door. So hold on, Miss Hamilton. Let me close this breakout room. Eight. All right, so Miss Underwood and Miss Hamilton, go ahead and join that breakout room. All right, Mr. Marvin, I am just looking for Mr. Fry, which I could probably send him a message.
He's not.
All right, I'm gonna send a message to Mr. Fry. So in the matter of the state of Michigan versus Kelly Dwayne Moe. Files number 24-21931 FH and 24-22090 FH. This is the date and time scheduled for request and summons for probation violation. Mr. Moe has failed to appear, so I will issue a bench warrant on each file and set bond in the amount of $25,000 cash. These are actually. So these are technical probation violations, Mr. Jones. So if he, that's the 14-day, right?
Yeah. He hasn't showed since he's been let out of jail.
Yeah, so if Mr. Mo were to report as soon as possible, he'd only be looking at 14 days, but if he goes too long, then it becomes a non-technical. So we will try reaching out to Mr. Mawad, because I do know Mr. Mo tended to always show up with Mr. Mawad. All right, I'll put a note on that file. Okay, takes care of Mr. Mo. You're here on Marvin? Okay, so we are gonna step off the bench for just a minute so everybody can use the restroom. So we'll be right back, Mr. Marvin, while we're waiting for Mr. Fry.
Okay.
Yeah, that's
Yes, thank you, Judge. Thank you.
Is not.
Hello.
Rhonda, she's just taking a brief break. She'll be right back.
Thank you.
You're welcome.
Just take a break. Go take a pee. Oh, she said.
Good break home. Friends. So Mr. Marvin, Mr. Fry is down in probate. He'll be up in just a minute.
Okay.
There we are. All right, Miss Hamilton. All right, so we're back on the record. Miss Underwood, have you had a chance to speak with Miss Hamilton?
Yeah. I have, Your Honor.
And how would you like to proceed with Miss Hamilton?
Miss Hamilton has some things in district court that are also going on, Your Honor. I would ask that this be put out for a week and we see how that presents itself. And I would ask that the not guilty plea continue.
All right, so Ms. Underwood, I'm gonna set it out to July 23rd at 8:30 in the morning. If there's some, yes, Ms. Adams?
I apologize. I believe we still need to arraign her on the 4-1 file.
Oh, yep, you're right. So Miss Underwood, we actually had 2 files, and I think I only arraigned her on the 4-3 file. So Ms. Hamilton, it's the same thing, but I don't think we went through it the last time we were here. So in the matter of people of the state of Michigan versus Jessica Sharice Hamilton, file number 20-19941. Is that the file, Ms. Underwood? Yeah. So Ms. Hamilton, on that same file, we have 2 things: a contempt of court for failure to appear for a probation violation hearing on November 20th. And then there is a request and summons for probation violation for failure to report on or about November 6th of 24 as instructed. That was a technical violation at that time, but it is now a non-technical violation because of the length of period of time. So on both of those, Ms. Hamilton, on the contempt of court for failure to appear, you're facing up to 93 days in jail. On the probation violation, if you plead guilty or found guilty, you're facing up to 4 years in prison. We appointed Ms. Underwood on the 1 file. Do you want Ms. Underwood appointed on this file?
Yeah.
Okay, good. And then, so we will appoint Ms. Underwood on both files. Ms. Underwood, I will set this over for a pretrial on July 23rd at 8:30 in the morning. That's my next available one. If there's a resolution sooner, we will accommodate you, bringing her in quicker, okay?
Thank you, Your Honor.
All right, and Ms. Hamilton, I'll continue your not guilty, please, okay?
All right, thank you.
Thank you.
Your Honor, does that conclude my docket with you today?
I believe it does, Ms. Underwood, so I'm just checking. Ms. Hamilton, you can go.
Okay, thank you.
Thank you. It does, Ms. Underwood, and actually, the show causes failed to appear, so we should be good. All right?
What show causes were those, Your Honor?
It looks like I had, well, actually, the 8 o'clock on John Vetter, he requested court-appointed counsel, but I adjourned it to August 13 because the probation officer said if he paid everything off, they were just going to dismiss.
Okay, August 13th.
And then Mr. Moe was set for a show cause at 9 o'clock, or Miss Moe, I don't know, it's Kelly Moe. Well, Dwayne's middle name's probably a man. They failed to appear, so I issued a bench warrant on that one.
Okay.
All right.
And these were show causes, so we weren't appointed.
You were appointed on Better, but
Okay.
it'll probably get nully pressed, but Mo didn't appear, so we didn't appoint.
Great. Thank you, Your Honor.
Great. Thank you, Ms.
I'll see you
Underwood.
after lunch.
Yes, oh, yep, we have Maria Rodriguez. Yep, thank you. All right, Mr. Marvin, I'm sorry. It's been a morning. So,
I thought it was done, but yeah, I'm done now. Yeah.
Okay.
So Mr. Fry will be up in just a few minutes, okay?
No problem.
All right, thanks.
Judge, could I ask you a question about your docket?
Sure.
On the PPO hearing at 11, it's Deschler v. Harrington. It looks like there was a retained for the petition.
Miss McClure, I swear it's your microphone. Yeah. If you're a little bit closer, I can hear you really well, but the rest it's kind of muffled.
On Deschler v. Harrington.
Yep, audio's fine
there
now.
was it looks like there's a retained attorney for the petitioner. I just wanted to double check that so I can remove it from our calendar.
No, I don't have that. I have John Glazier was court appointed. The last thing I have is June 3rd, a request for discovery. Miss Adams. Hold on. It might be in the system. And
I was just looking from the docket. It says attorney Goldman and defender. So usually that indicates to me there's a retained attorney.
But I don't see Goldman in the file. Miss Adams did, that might have been something previously, but Miss Adams is Mr. Goldman. Like, I don't see Goldman's. I don't see Goldman anywhere.
I don't know why that appeared on there.
I think that's just an error.
Hold on.
Sorry.
1 second.
But I do have the plea agreement form on Mr. Marvin, so we'll wait for Mr. Oh, that's Mr. McCready is Mr. Marvin's prosecutor.
It is, but I think he got pulled into another courtroom and he sent me a message to cover if I could.
Okay.
Judge, there was an appearance by Mr. Goldman on March 24th. I don't know if that's on this violation. I'm not sure.
Well, this show cause is from May. So May 14. He did not, Mr. Goldman did not do the motion to show cause, so I really don't know. So we'll wait and see.
Okay, it's Mr. Sneed's anyway. I just wanted to know whether I could take it off the calendar, I guess.
We'll let you know. All right, now I got Mr. McCready on Mr. Marvin. So Mr. McCready, Mr. Fry's down in Judge Sala's court, so it will just be a few minutes.
Good.
Judge, did you already handle the Noah Finley case?
It did. Mr. Fry requested an adjournment to September 17th at 8:30.
Okay, thank you.
You're welcome.
All right, I'm gonna go ahead and log out as Mr. McCready has that last one. I don't think there's anything else.
Okay, and we'll let you know about the 11.
Thank you.
Okay. Sorry about that, Mr. Fry. All right, Mr. Marvin, I got Mr. Fry back. He's downstairs, so. Mr. McCready, okay. All right, this is in the matter of people of the state of Michigan versus Chad Thomas Marvin, file number 25-22259H. And let's see here. I did have a plea agreement form, which I have promptly lost because it's been a while. And so I did have one. So let me see, it got emailed to me. So let me see if I can find it. No, I got one. Oh, here we go. All right, so I do have a plea agreement form on Mr. Marvin. So I have Dave McCready appearing on behalf of people and Brian Fry appearing on behalf of Mr. Marvin. And this is the date and time set for a pretrial. I received a plea reduction or plea agreement form or reduction, which states that the people have offered that if the defendant were to plead guilty to count 2, felonious assault with a habitual offense, 4th offense notice, that would become a 15-year felony max. And there would be no upfront MDOC incarceration, which means that the judge would have discretion to determine a jail term or no further jail at the time of sentencing. Is that a correct recitation of the plea, Mr. McCready?
That is, yes.
Mr. Fry, that's the plea offer, as you understand it?
It is, Your Honor.
All right, Mr. Marvin, do you fully understand the plea offer that's been made?
Yes, Your Honor.
All right, and Mr. Marvin, do you wish to avail yourself of the plea today or not?
Yes.
All right, so Mr. Marvin, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Now, Mr. Marvin, we will get to you a plea agreement or I'm sorry, an advice of rights form at the jail for you to review and sign and get back to us. So you heard the plea agreement that I read off. So is it your intention then today to plead guilty to count 2, assault with a dangerous weapon, which alone carries a maximum penalty of up to 4 years in prison, but you'd also be pleading to the habitual offender 4th offense notice. So that means the maximum penalty could be up to 15 years in prison. Do you understand that part?
Yes, Your Honor.
And then the agreement is that there would be no prison term at the time of sentencing, but the people have made no other position regarding jail or probation. Do you understand that?
Yes, Your Honor.
All right, and it's your intention to plead guilty to that?
Yes, Your Honor.
Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Absolutely. Yes.
Neither, okay, good. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. McCready?
That's correct.
Mr. Fry?
Yes, Your Honor.
And Mr. Marvin, is that correct as far as you're aware?
Yes, Your Honor.
All right. So, Mr. Marvin, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. I'm sorry. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Marvin, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions of bond, or the terms of any sentencing or plea agreement, and otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. I'm sorry. Do you have any questions about the rights that I've given to you?
No.
How do you wish to plead to the charge that on or about March 18 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of assault with a dangerous weapon? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than the agreement that was placed on the record?
No. No, ma'am. No, Your Honor.
Okay. And how do you plead to the habitual offender fourth offense notice that you have 3 prior felonies? Guilty to that as well?
Yes, guilty.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. McCready?
No.
Mr. Fry?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Marvin?
No.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, Mr. Marvin, on March 18 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right. And did you come in contact with a woman named Jennifer Lynn Allen?
Yes, Your Honor.
All right. And did you have a knife or a weapon on you at the time that you were in contact with her?
Yes, Your Honor.
And did you threaten her with that knife, wave the knife at her, point the knife at her, stab her, or anything of that nature?
Yes, Your Honor.
Okay. Which one did you do?
Waved it at her.
Okay. And would you agree that?
Threatened her with it.
Okay. Would you agree that that would be considered an assault and would put a person in fear?
Absolutely.
Yes.
But you did. Okay. Mr. McCready?
Yeah, it was the words he used in addition to waving the knife at her. Isn't that correct?
Yes. Yes, Your Honor.
Okay, I'm satisfied.
Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
And Mr. Fry?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm sorry. I am referring this matter to the probation department for a pre-sentence investigation. And I will set sentencing for Mr. Fry, if you are available. I believe we're doing August 22nd at 8:15 in the morning.
Yes, Your Honor. I believe he has sentencing on a couple other cases already scheduled for that time.
All right. So, Mr. Marvin, I'm going to set sentencing for August 22nd at 8:15 in the morning. You do have the right to be present in person, or you can appear via Zoom. Do the people have any preference?
People are fine either way, Your Honor.
All right, so Mr. Marvin, do you want to appear via Zoom or in person?
Zoom is fine, Your Honor.
All right. Mr. Marvin, your prior convictions, would you agree that on or about March 10 of 2003, you were convicted of operating while intoxicated, third offense in Antrim County in Michigan.
Yes, Your Honor.
And would you agree that on May 20th of 2010, you were convicted of delivery and manufacture, maybe ecstasy, MDMA, on May 20th of 2010 in the 39th Circuit Court of Lenawee?
Yes, Your Honor.
And would you agree that on that same date, you were convicted of felony firearm in the 39th Circuit of Lenawee County?
Yes, Your Honor.
Okay. All right. Okay. I don't remember where I stopped, but I think I asked you if I complied with MCR 6.302 B, C, and D, did I not?
Yeah, sure.
All right, I accept the plea. It has been given understandably, voluntarily, accurately, has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. As I said, I'm going to set sentencing for August 22nd at 8:15 in the morning. I'm going to refer this matter to the probation department for a pre-sentence investigation. So, Mr. Marvin, someone from MDOC is going to come over and meet with you, give you a packet to fill out. When you meet with them, be truthful about your background, the events that occurred. And we'll see you back on August 22nd at 8:15 in the morning via Zoom. And anything further, Mr. Fry or Mr. McCready?
People are all set.
Nothing further, Your Honor.
All right. All right. Thank you, Mr. Marvin. We'll see you back. Sorry for the delays this morning.
That's okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Thank you, Mr. Fry. All right. Mr. McCready, don't go anywhere. So I have, it's 11:10. I have a PPO hearing that was scheduled at 11. And I know Ms. McClure, there was some confusion. So hold on a second. Ms. Deschler?
Yes.
You don't have Mr. Goldman as your attorney anymore, right?
No, I do not.
All right. So there was some confusion as to why Mr. Goldman's name was on the docket. But Ms. McClure, I think, was going to appear for this, but it's a PPO trial, violation trial. We did give notice to the people, so I don't know if you want to get Ms. McClure.
Yeah, let me check with her.
All right, thank you. So hold on, I just need the prosecutor.
Hey, Judge. Isaac's gonna be covering this. And
Who is?
Isaac. And he just said that he'll be up in 5 minutes.
Okay, great. Thank you.
You're welcome.
All right. So, Mr. Glazier, about 5 minutes.
Yes, sure.
So, you're Bailey Deschler, right?
Yes.
And then, or one of you, no. Is Trevor Harrington here?
I haven't seen him yet. I talked to him 2 days ago.
Okay.
But I don't know.
For some reason.
All rise.
All right, Mr. Sneed. The petitioner is present in the courtroom. All right, I'm gonna call the case, but this is in the matter of Bailey Deschler versus Trevor Harrington, and you can stay right there. Stay right there. Okay. File number 25-52425 PP. This is the date and time that was set for a violation of probation trial. I have John Glazier was court appointed to represent Mr. Harrington, and I have Isaac Sneed appearing on behalf of the people. This matter was set for 11 a.m. It is now 11:26 p.m. or a.m. I do have Bailey Deschler here present in the courtroom, and I do not have Trevor Harrington. So, Mr. Glazier, I know you might have mentioned a minute ago that you had some conversation with him a couple of days ago, but he has not appeared.
I spoke with him for about an hour in my office, and I expected him to be. Those things were I said.
Well, he's not logged into Zoom and he's not present in person. So I can issue a bench warrant for his arrest and set bond in the amount of 10,000. Obviously, Mr. Glazier, you reach him. Just let us know and we will get him in right away.
May I address the court?
There also would be a contempt of court for failure to appear possibly. Yes, Mr. Sneed.
Thank you, Your Honor. I would request if the court could provide a copy of the motion in order to show cause to our office again, please.
Okay, we will do that. All
Thank
right,
you.
thank you. So he's not appeared, so I issued a bench warrant for his arrest. If he's arrested or contacts his attorney, we will bring him in and have the prosecutor's office contact you. All right. And if we re-notice it, we'll mail a notice to you too. All right, thank you. All right.